very much.
Yes, thank you.
Okay. All right,
This
Mr.
meeting
Bornstein, go
is being
ahead.
recorded.
Yep, you're still muted. There you
This is Gary Bornstein, counsel for Epic.
go. Okay, Mr. Boutros, go ahead.
Good morning, Theodore Boutros for Apple.
And then Ms. Forrest, go ahead.
Catherine Forrest for Epic.
This is Renee, the court reporter. Sounds good so far. Thank you so much.
Okay.
Thank you.
Right. All right, I'll let the court know we are ready, but whenever the court will be set to come in. Would council like to start early, or you want to wait till we've got about 8 more minutes?
We're fine starting early.
Agreed.
Up to the court whenever the court would like to start is fine with us.
Okay. Okay, I'm going to go ahead and read the admonition here. This is the courtroom clerk. Persons granted remote access to proceedings are reminded of the general prohibition against photographing, recording, and rebroadcasting of court proceedings. See General Order 58 at paragraph 3. Any recording of a court proceeding, including screenshots or other visual copying, is absolutely prohibited. Persons violating these prohibitions will face sanctions, including removal of media credentials or denial or restriction of entry to future hearings. Thank you.
Okay, good morning, everyone.
Good morning, Your Honor.
Let's go ahead and call the case. I know it's early, it's 9:24, but at this point, we've maxed out on our license. And so no one else, we can't wait, even if we were waiting for anybody else, it wouldn't matter because we've maxed out. All right, so let's go ahead and call the case and we'll get started. Ms. Stone.
Calling Civil Action 20-5640 Epic Games Inc. versus Apple Inc. And counsel, please state your appearances.
Catherine Forrest for Epic. Good morning, Your Honor.
Good morning.
Gary Bornstein, also for Epic Games.
Good morning, Your Honor. Theodore Boutros for Apple.
Okay, good morning.
And good morning, Your Honor. Richard Doran for Apple.
Okay, good morning. So just a few things, preliminaries, especially for those folks who are watching. We have a lot of people who always want to raise their hands, and it doesn't matter. We're not going to call on you, so you should just know that. You can raise your hands. It's as if, think about where you are as if you were in a courtroom sitting in the galley. We just don't let you talk. You're not admitted to the bar. You're not representing the parties. This isn't well, it's a court hearing. And so at a court hearing, we have people who are designated to speak. There are actually lots of lawyers on each side. And I advised all the lawyers that I was only interested in having on the platform those who were going to argue. I understand for the plaintiffs, Mr. Bornstein, you're going to be arguing likelihood of success on the merits, and Ms. Forrest, you'll be arguing
That's
everything
correct.
else. And then with respect to defense, Mr. Doran, you will be speaking to likelihood of success on the merits, and Mr. Boutros, everything else.
Correct, Your Honor.
And I'll also be handling the scheduling issues when Your Honor reaches those.
Okay, that's good to know. Let me just say, I've read all the papers. I have a number of questions. unlike the Court of Appeal, you aren't going to get 15 minutes aside and that's it. This is going to be a long hearing. We are going to talk about many issues. But I really am not interested in you regurgitating what I've read in the papers, because I've read the papers. I'm more interested in what you didn't respond to, what points that the other side made that perhaps are not your strongest points, and so you avoided the issue. I'd like to know, if anything, what you have to say on those topics, and we'll go through them all. Hopefully, Mr. Doran has done a little practicing, so he's watching the screen and he gets my my physical gestures to warn you to stop. So stop, so that I don't mute you, because we're going to be here for hours, I suspect. And once in a while, if I start hearing the same things over and over again, and you don't listen, or you don't look, and you don't notice that I'm trying to get you to stop, I'll mute you. If we were in the courtroom, I could do that. And my court reporter would pick up what I have to say as opposed to what you have to say. It's a little bit more difficult on Zoom because someone actually has the platform. But I do have a control. So I hope not to do that, but please pay attention. And I suspect that you'll end up repeating some of what you say, but really try to avoid it because I've already read it. And there are lots of big issues here. And I'd like to hear what you have to say on some of the things you didn't talk about. Let's first talk about some of the issues that were raised in your joint statement. This is docket 91. Ms. Forrest, can you tell me why EPIC hasn't responded to the subpoenas in the related cases and hasn't produced documents, especially given the fact that it's now trying to push forward something that's the exact same topics, yet it appears to be somewhat recalcitrant in the other case.
Yes, Your Honor, thank you. We, at the time that we were on the verge of really beginning production for the subpoena, we were also on the verge of filing this case, and we expected that, in fact, there would be some sort of efficiencies to be gained and some coordination with certain of the discovery. So we did not produce then, but are fully prepared to produce with alacrity right now, quite fulsomely in those cases. And so it was a timing issue, Your Honor, having to do with the commencement of this litigation.
Well, Apple's already produced. So I find it to be convenient for you, not convenient for anybody else. So you will produce. Are you ready to
Your
produce?
Honor, we are ready to make a significant production. And one thing that would be of assistance to us in terms of moving forward generally would be to understand exactly what's been produced in those cases generally. We haven't yet been able to receive information on that.
Ms. Forrest, I don't see how that's relevant to your own production. How is
Your
that
Honor,
relevant?
it's really a separate point. You're absolutely right. We will make production with alacrity on the materials that have been requested of us.
Are the documents ready? Can you produce this week?
We cannot produce this week, but we can produce next week. And the reason I say that, Your Honor, is because we have a holiday today, and there's also some additional matters that are sort of coming up over the next couple of days. And but we can produce as early next week as possible.
All right, who's talking about these issues for Apple?
Yes, Your
Mr.
Honor.
Dorn? Have you had any discussions with them? Is this news to you? Is this expected?
We've had discussions with them about when their production would begin, and they have assured us that documents would be coming soon.
I want a date certain, Ms. Forrest. Wednesday of next week, Monday of next week?
Wednesday of
Tuesday
next week, Your Honor.
All right, production to occur by Wednesday of next week. By this Thursday, October 1, I want a protective order in this case to be lodged with the court so that I can issue it. That protective order should, you're welcome to negotiate it if you want, but the Northern District's protective order is sufficient. The only thing you have to change is the provision with respect to discovery. It should be consistent with my standing order. If you want to change anything, that's fine, as long as you agree. If not, use the Northern District form, okay, by this Thursday.
Understood.
Because we are moving forward quickly, there will be no amendments to pleadings without good cause and only upon motion. We have Apple's counterclaims. I don't think anybody has any need to amend the pleadings, right?
We don't intend to amend, Your Honor.
Correct, Your Honor.
All right. All right, I've got some other things, but we'll deal with them later. Let's start with likelihood of success on the merits. In your briefing, you both identify elements, and I don't think that there is any material difference, but just to confirm, I just want to make sure that we're on the same page. With respect, let's start with Section 2 of the Sherman Act. So to establish liability under the Sherman Act, a plaintiff must show the possession of monopoly power in the relevant market, the willful acquisition of that maintenance of power, and under Qualcomm, which was cited by plaintiffs, they indicate a antitrust injury. Seems not controversial, right, Mr. Dorn?
Yes, Your Honor.
So you agree that that's an element?
Antitrust injury. Yes.
Yes. Because in your recitation of the elements, you didn't include that, but you did include the additional phrase from U.S. versus Grinnell, quote, as distinguished from growth, that is the acquisition or maintenance of monopoly power, as distinguished from growth or development as a consequence of superior product business acumen or historic accident. Again, this is context. I don't think it's necessarily an element, but I don't think it's wrong in terms of the law. Mr. Bornstein, you agree?
I do agree.
All right. So even though those were different, there's really no material issue. I think everybody can also probably agree that it is a threshold step in any antitrust case to accurately define the relevant market. That is the area of effective competition. Correct? We all agree on that fundamental proposition?
Yes,
Mr.
Your Honor, of
Bornstein?
course.
Yes, Your
Mr.
Honor.
Doran? And that's really where they say the rubber meets the road, right? The relevant
Indeed.
market. And it's clearly where I have the most questions, is the relevant market. So let's start there. I am curious, Mr. Bornstein, it seems to me that, let's start with one. You've identified two relevant markets, but the first that you've identified is the market for the distribution of apps compatible with iOS users of mobile devices. And you refer to that as the iOS app distribution market, which is, as we know, a single product market, right?
That is correct, Your Honor. Single product aftermarket, to be precise.
A single product, right. So that's my first question, which is, why is it that nowhere in your expert's declarations, and he submitted two, does he ever describe this as an aftermarket? And why doesn't he ever go through the factors that we as courts have to consider in determining whether an aftermarket exists.
Well, Your Honor, Dr. Evans doesn't use the word aftermarket, but the concept is there for sure. And I would disagree as well that he doesn't touch the factors, if I could explain. When I say the concept is there, he talks about how app distribution is downstream from the software platform, from the iOS smartphone software platform.
Have you asked him? I mean, the concept of an aftermarket is a very known, common description of what we're dealing with. Why doesn't he use that term?
Your Honor, I can't say why he doesn't use the specific word aftermarket, but I would submit that it doesn't make a difference whether he used the specific term, given that the concept is there, I believe, in spades.
All right,
And
so I've got his declarations. We're talking about docket 62 and docket 88. Where does he describe the elements of an aftermarket? I'd like paragraph numbers, please.
Sure, Your Honor. So I would start by just pointing the court in his initial declaration, docket number 62, to the description of stores that begins on paragraph 9, which he makes very clear are downstream products from the software platform. He then turns, Your Honor, in the discussion of market power in the platform to the switching costs and the information costs, which are important components of the NewCal test in assessing a single product market. I would clarify that in NewCal, there is a difference between whether something is an aftermarket and whether there is a properly defined single product market. In order to get to a properly defined single product market, you need to have the aftermarket and then also these switching costs or information costs and other items that are defined and described in NewCal. To get to the aftermarket question, it's just the first of the NewCal factors, which is whether the market at issue, here app distribution, is wholly derivative of the primary market, here the software platform. And Dr. Evans makes clear in the declaration in the sections that I referenced, and I think, frankly, common sense tells us the same thing, that the distribution of apps on the iOS platform is wholly derivative of the iOS platform itself. NewCal, for example, distinguished the Third Circuit decision in Queen City Pizza, where there was no properly defined single brand market. That was a case, Queen City Pizza, was a case where they were Domino's Pizza franchisees who were bringing suit. And the court said, wait a minute, the purchase of ingredients for Domino's Pizza is not wholly derivative of the Domino's franchise. You can make a pizza at home. You can make a pizza in other stores. You can't make an iOS app distribution, and you can't distribute on iOS separately from the platform itself. It is wholly derivative under NewCal and therefore constitutes an aftermarket. And Dr. Evans does make clear that it's downstream.
Mr. Bornstein, you've created, in many ways, you've created a fail-safe definition, right? Because it is a single product definition, then by definition, they have a monopoly.
Well, I disagree with that, Your Honor. They have a monopoly only because they've engaged in conduct that prohibits competition in that market. If, for example, there were other stores allowed on the iOS platform, then there would be competition in that single brand market. NewCal was the same. It was a situation where there was a single brand market, but the independent service operators who were seeking to service the copiers, the Icon copiers in that case, were seeking to compete with respect to that market. And Your Honor, I'll interrupt myself just for a second to say I don't see the court on video. That's fine if Your Honor has intentionally taken yourself off. I just want to make sure we haven't lost the court. Okay. I was worried we might have lost you.
No, my mistake.
Okay, no problem. And so you can have a single brand market in which there is not a monopoly if the monopolist is not prohibiting competition in that market. And the Kodak case in the Supreme Court is a good example, as is NewCal itself, where there was a
Okay,
proper
so
single brand market.
Let's go back to the elements. So you have switching costs. What else do you have?
So in NewCal, there are four factors that the Ninth Circuit considered. The first one is that the market be wholly derivative of the primary market. And I've talked about that at length and won't go through it again unless the court has further questions. The second one is that the restraints at issue occur only in the aftermarket and not in the primary market. And that's satisfied here. We are challenging restraints that occur with respect to distribution and restraints that occur with respect to payment processing. And we are not challenging restraints that are applied at the software platform level, which is the primary market.
And I need you, Mr. Borenstein, to interlace the paragraphs of the expert's report.
Well, the second factor, Your Honor, I would say is not a matter that he discussed. It's not an economic question. The second factor is one that asks, what are the restraints that the plaintiff is challenging? And I would submit we don't need economic evidence to describe the nature of our claims and the nature of the specific markets in which the restraints occur. So I don't have a place to point for that one.
Speaking of which, did he define the market or did you? That is,
Dr.
did the lawyers define the market, or did you go to Dr. Evans and say, we have this issue, we'd like you to take a look at it, and did he come up with this economic argument himself?
Yes, Your Honor. We had a discussion with Dr. Evans about the issues in the case. We were speaking to him before the complaint was filed, and he has his independent views on the market at issue, which he's very careful, in fact, Your Honor, in his declaration to say that based on his analysis so far, he's reached a preliminary conclusion as to the definition of the market, and he is continuing to do work as the case proceeds and he gets more information.
The reason I asked was because his declaration raised the question. That is, his declaration indicated that the counsel asked him to address these issues as opposed to, well, you've answered the question, it's fine. The way he framed the analysis suggested to me that there was this potential that the lawyers had framed the market, not the expert.
And Dr. Evans' reputation would not permit him to just take a market that was thrust on him by counsel, and we wouldn't do that with him and ask him to put his name on the line if he didn't believe in the argument that he was developing and presenting to the court.
And does he have any reservations about the ability of either Professor Hitt or Professor Schmonzles? I don't know if I'm saying that right.
I believe it's Schmalensee, Your Honor.
Schmalensee. To opine on the topics in terms of their expertise?
Dr. Evans certainly has no reservations about Professor Schmalensee. The two of them have co-authored several books together. So I think there is a great deal of mutual respect between the two of them. And I expect that Mr. Doran would say the same about Professor Schmalensee's view of Dr. Evans. Professor Hitt, I believe is the right way to refer to him, is, as I understand it, not someone who has an economics degree. He's a professor of management and has a PhD in management. But I do not know one way or the other whether Dr. Evans has a view on the competence of Professor Hitt. He has a view on the opinions that he's expressed.
And they disagree.
They do, Your Honor.
They do disagree, which just highlights the fact that between the University of Chicago professor and the MIT professor, we have a disagreement over what the relevant market is, right? So this is not something that is without debate within the community. You would agree with that?
Well, I agree that there are people on both sides, but I would say, Your Honor, that the test that Professor Hitt applied is just not the right test under the law. Under the law, we look to a hypothetical monopolist test to assess whether or not a monopolist in the market that is being assessed could impose a SNP, SSNIP, small but significant non-transitory increase in price. That is the recognized test under the case law and under the guidelines that are applied by the Department of Justice and the FTC. And Professor Hitt didn't do that test. He acknowledged in paragraph 17 of his declaration that it is the right test, but then he failed to apply it. What he did is he looked to see whether there are other alternative distribution paths for Epic to get Fortnite out to people who want to play the game. That's not the test. That would be like saying that there is not a market for ride sharing and taxis if people can also walk or bike or get a friend to drive them or take public transport. What you need to do is not just assess whether or not there are any alternatives. You need to assess whether or not the alternatives impose some kind of competitive discipline in the market that's being proposed. And that's what the hypothetical monopolist test or the SNP test is intended to do. And Dr. Evans.
Let's go back to the aftermarket. You want to finish that up?
Sure, Your Honor. So I covered 1 and 2. The third factor in NewCal is whether or not the power that's at issue derives from express contractual agreements that were reached in the primary market. So here, there are no such contractual agreements in the primary market between the users of the iOS platform and Apple, that they will only download apps in certain ways. And Apple has not argued to the contrary in its papers about any contracts between users and Apple. I would have expected to see that.
There are contracts, there are licensing agreements between the plaintiffs and Apple.
That's correct, Your Honor. There are contracts between the developers and Apple for sure. But the relevant question in assessing the third factor of NewCal is whether or not the users have signed on to a contract, or whether instead the power that Apple has over the users derives from their access to the consumers. The court in NewCal talked about special access to consumers that derives from the relationship that, in that case, Icon had with the people who bought the copiers. Here, the information cost and switching costs and so forth that I will talk about in the fourth factor in a moment, those all derive from the relationship that Apple has with its users, and not from any particular contractual commitment on the part of the users to limit their access to apps on the platform. And so the fourth factor, as we've talked about a bit, and I can probably go through it more briefly, is in some sense the most important, and it is whether competition in the primary market for the smartphone software platform, whether competition in that primary market imposes competitive discipline in the aftermarket. So to put it in less antitrusty words and more English words, does competition to sell iPhones or iPads impose any discipline on Apple's conduct in the aftermarket? And this is the subject that Dr. Evans talks about at length, where he talks about the switching costs and the information costs that people face. And frankly, another very important factor is the relative costs associated with the two things. An iPhone is...
Where does the video game market come into play? You seem to ignore that entirely. And the Sherman Act is concerned about competition, right? It doesn't care about Epic Games specifically. It cares about competition, because through competition, we get innovation. Consumers are certainly benefited from that. And if we look at the video game industry, of which your client is a part, the 30% of which you complain seems to be the industry rate, right? Steam charges 30%, Microsoft, 30%, GOG, 30%. If you go to console stores, PlayStation, Xbox, Nintendo, all charge 30%. Physical stores, GameStop, Amazon, Best Buy, Walmart, all charge 30%. Apple and Google charge 30%. Now, your client doesn't. Okay, fine. But where is the lack of competition where that which you're complaining is seems to be what all the competitors are charging?
So if I could try to tease out two issues that Your Honor raised in the question, and if you want me to respond to the other one, I'll switch, but I am trying to be responsive to both. The first is you asked about the video game market, which I would submit is not the market that's at issue here. We have a market for apps broadly on the iPhone. With respect to the specific point about the 30%.
But why do you say that? Sure.
I say that, Your Honor, because.
And the reason in part I'm asking is because, at least from what I've read, 84% of all apps on the iPhone are free. Your client complains bitterly about the 30% in his market, which is video game apps. So I looked at percentages of licensing fees, or whatever you want to call it. He calls it a tax, but for video games. So and it's all 30%, and you just want to gloss over it. You don't want to address it. You just say it's not it. So why?
Well, what I want to make very clear, Your Honor, is we don't actually challenge specifically the 30%. The 30% is an outcome of the anti-competitive structure that we do challenge. We would like to be able to distribute directly on the iPhone ourselves without going through the App Store. We would like to be able to process payments ourselves on the iPhone without going through the App Store. We don't have a number that we are advancing that the court, for example, should conclude is the right number. I would agree with my friends that that is not really the role of an antitrust court to pick a price and set a number. The issue we're concerned about here is the structure in which there is no competition and 30% is selected entirely by Apple without any competitive constraint from other distribution.
Mr. Bornstein, you say that, but the evidence in that market doesn't support your blanket assertion. That's my point of referencing the rest of that, the rest of the players in that market, is that there doesn't seem to be evidence to support what you're saying.
Well, Your Honor, there are two things here. This is why I started earlier by referring to the proper market. The market that is at issue here, in our view, is not all of the different ways that somebody can reach a user to play a video game. That's not the right market. As Your Honor said at the beginning, the market definition is obviously an important part of the dispute here. And we're going to, I assume, continue talking about this through the rest of this litigation. But in order to assess what the right market is, the court needs to assess whether these alternatives impose a competitive constraint on what Apple can do in distributing apps. And I think it's clear that that those markets cannot. You can't, for example, play an Xbox when you are, on a bus. You can't.
No, but you can play a Switch, which you buy from Nintendo, right? You
can play a Switch, but there are, as Your Honor has seen in the papers, 63% of iOS users who play Fortnite play only on iOS. Most people don't have multiple devices to go out and buy a gaming console or a separate gaming PC, and certainly they don't multi-home in terms of using two different mobile devices, an Android device and an iPhone device. And what I think should weigh into Your Honor's consideration of this 30% and whether there is evidence that it is the product of an anti-competitive structure is the staggering opposition in the marketplace to this 30%. It's not just Epic who is complaining. It is the industry at large that is complaining about the 30% that Apple charges. And there is no doubt, I would I would say that competition for the distribution of apps has been prevented completely on iOS. If it turns out, Your Honor, that after the opening up of the iPhone and the opportunity for people like Epic to do direct distribution, if it turns out at that point that Apple is providing a service that is worth 30% and people will pay it in order to get what Apple is providing, God bless, after, that's fine. They are entitled to charge 30% if they can get it in a competitive market. Our concern is there is no competitive market right now, and there is no constraint on what they can charge.
All right, anything else on NewCal?
No, Your Honor. I'll just point out the other another important factor in whether there is a competitive constraint is just what Your Honor was talking about. Specifically, Google also charges 30%. In the primary market, there is a duopoly between Android and iOS, and there is no option for people who would like to go to a different place. So that, to my mind, is another reason why the primary market is not a source of competitive constraint for Apple's conduct in the aftermarket.
Mr. Doran, response.
Thank you, Your Honor. First of all, I guess I'll begin where the court did with Mr. Bornstein, which is the single market, single brand market. Your Honor, of course, correctly notes that this is something of a unicorn in antitrust law and a very specific thing. Judge Alsup in the SiStar litigation explained that it's counterintuitive that any product is so unique that it suffers no actual or potential competitors. This case does not fit the narrow exceptions created by Kodak and NewCal. There are two fundamental differences. In both of those cases, the plaintiffs were locked in to dealing only with Kodak and using Kodak parts exclusively and using Kodak repair personnel exclusively. And in NewCal, there was an extension of service contracts after there had been those plaintiffs had been locked in to dealing exclusively with NewCal. So first of all, to fit the Kodak or NewCal exceptions to the general rule that there's no such thing as a single brand market in the antitrust context, the developer here in this case must be locked in. But Your Honor obviously has the record well in hand and knows that there are many channels of distribution available to Epic to distribute Fortnite. And while Mr. Bornstein referenced a 63 million person figure, in that same paragraph 3 of Mr. Sweeney's declaration, he explains that only 10% of the average daily players of Fortnite are using iOS devices, meaning that 90% on any average day, 90% of the people who are playing Fortnite are using a device other than iOS. We also know, Your Honor, that Fortnite is based on, and Epic's business model is premised on, interchangeability of platforms. They urge people to use various platforms. And while Mr. Bornstein has asserted that not everyone has separate, that not everyone has separate or multiple devices, there's no evidence in the record on that. And instead, when we talk about those who have accessed Fortnite by one device, that does not tell us how many people are actually regular players on it. And there we see it as simply 10%. So first of all, Your Honor, there's substantial interchangeability. Epic uses that as one of its basic promotional properties, that people can go on different devices and continue to play, that they can make purchases on one device and then go to another device and continue to use it. And 90% of the daily players are using other devices. Secondly, and equally importantly, both Kodak and NewCal involved once the person was locked in, there was an undisclosed change of terms that impacted the plaintiffs in a negative way. In Kodak, the exclusivity of dealing exclusively with Kodak parts was interposed after the contracts had been entered. In NewCal, the extension of the service contracts occurred after they were already locked in with NewCal. And Epic has cited to Judge Oreck's decision in the Teradata case on tying generally. But at page 16, Judge Oreck also comments on Kodak. And he says that the Supreme Court in Kodak adopted a limited exception for a single aftermarket product in which customers do not agree on restrictions that were undisclosed at the time of the purchase of the product from the primary market. There is no question here that any disagreement that Epic has with terms in Apple contracts with Epic, not with consumers, but with the distributor of these video games, has existed since 2011 when these in-app purchases and the 30% commission first went into effect. Those terms have not changed, and those terms have remained constant. So there is no aftermarket or aftermarket claim or derivative market under the standards set forth in Kodak and NewCal. One other comment, Your Honor, is Mr. Bornstein noted that even in NewCal, the question is posed whether is competition in the primary market, whether that imposes competitive discipline on Apple. And plainly it does. In fact, you can see that in Epic's own conduct in this lawsuit, where it breached its contract with Apple on the eve of the issuance of the next season of Fortnite, a significant season with Marvel characters and much publicity. Apple gave Epic the opportunity to cure, to come back onto the App Store with that new release, and Epic refused. It refused because what Epic has told Apple throughout its relationship is that it is the smallest piece of the pie for Epic, and that if Apple doesn't toe the line with Epic, they will simply move on without Apple. You also see that in the revenue figures, which are estimated to be about 9.8% of Epic's revenue originates through Apple, through the Apple App Store. So there is substantial discipline on Apple in terms of its dealing with Epic. And Epic itself uses the options in the marketplace available to it, the reasonable substitutes, the reasonably interchangeable distribution channels, and the rough equivalents available through all the different platforms that Your Honor has already defined and identified to discipline Apple, if you will. And finally, Your Honor.
Let me ask you a question. And I asked you last time, perhaps you have an answer this time. And that is, I believe that Mr. Bornstein's right. There is an uproar in the marketplace about the lack of competition for iPhone apps. It's, you read the papers, I read the papers. It's there. It's not clear to me whether or not this case is actually going to get to that potential problem. If I know you may not think it's a problem, but there are clearly many people who do. And that's because of my questions about whether or not this is the right plaintiff, given the amount of competition for mobile games and where Apple is relative to Epic, or I think it's Tencent. Sometimes I do this. A huge share of Epic. But where is, in your view, where is the competition? Where does that 30% number come from? Why, as I asked before, why isn't it 10 or 15 or 20 or 30? There doesn't seem to be competition. And that's what we're concerned about. It's competition, not Epic, not any particular developer, competition.
Your Honor, two responses. First of all, to your specific question. The test for monopoly power is whether the alleged monopolist can increase prices by decreasing output. And as for monopoly maintenance claims, there needs to be some indication of anti-competitive conduct that is used to maintain and sustain a monopoly. Here, Apple established a business model back in 2008 when it first launched the App Store with 500 apps. Since that time, and in 2011, when it began in-app payments for in-app purchases, it set its commission at 30%. Neither of those things have changed since 2008, except the output has exploded. It has gone from 500 apps in 2008 to 1.8 million today. The commission has never been raised. In fact, it has actually decreased on subscriptions after 1 year, and that is something that doesn't involve Epic, Your Honor, but it does involve, other participants in the App Store. That has been decreased to 15%. As Your Honor has already noted, 84% of apps are absolutely free, and Apple recognizes nothing from those. And as to the effective commission, if you will, people were willing to pay, and Apple marketed when it obviously there was no whiff of market power, be it in video games, which, as Your Honors noted, there's profound competition in still today, or any other element of the market. Apple had no market power when it set 30%. We would suggest it still does not have market power in app distribution because there's so much competition in it. But what has occurred since that first app or first iPhone is that the devices have become profoundly more sophisticated. Apple's, they have provided profoundly more opportunities for distribution and also for higher tech apps, if you will. So as our experts testify, the effective commission has actually gone down over these years. And so, Your Honor, there is the test, if you will, for whether or not there is competition would suggest that there is competition. The Epic has identified no anti-competitive conduct by Apple. They use the term, but they don't cite any facts. Their expert doesn't even use the term. And on the pro-competitive side of the scale, the evidence is overwhelming.
Right, I interrupted you. You can go back to what you were arguing.
Oh, thank you, Your Honor. And by the way, on that, Your Honor, I would suggest that when Epic suggests that it doesn't challenge the 30% commission, that's exactly what it challenges. Epic, and I realize we aren't to the tying claim yet, but it's not credible that Epic has a problem with IAP as a technical element of the App Store. What Epic does not like is that IAP and the App Store are taking 30% of the business model that Epic has chosen to implement. Your Honor, finally, in terms of what market this court should be looking at for purposes of today's motion, the only evidence in front of this court relates to Fortnite and relates to Epic. Therefore, when we are talking about what is the relevant market for this motion, the only evidence that's been offered this court relates to Epic and Fortnite. The court has no other basis from which to evaluate the competition in the marketplace. In fact, the only other product identified is a reference to Pokemon by Mr. Evans, or Dr. Evans, as he attempts to distinguish Fortnite from some other devices. And regarding the question of the portability of Fortnite, Your Honor made the excellent point that the Nintendo Switch is about 4 inches by 9 inches. Microsoft offers tablets that are less than 10 inches by 7 inches. We all now increasingly carry laptops around. There are 100 million players streaming Fortnite on GeForce Now only. There's almost 250 million gaming consoles out there as well. And common sense tells us that a 12-year-old Fortnite player would prefer a big screen and a large control pad rather than playing with their thumbs on the bus. So, Your Honor, this notion that because a console is not portable, first of all, that's wrong as a factual matter. There are many portable options. And second of all, Epic has actually not put any evidence in the record that says that there is a portion of the population who is completely committed to playing solely on mobile. There's only broad assertions in that regard. So in terms of conducting the test required under the Sherman Act in looking at reasonable substitutes, rough equivalents, and reasonably interchangeable distribution channels, which is what we're talking about here, not consumer use, but distribution channels for Epic, they have not shown that any of the different platforms this court has identified are outside of the relevant market. They all must be included in the relevant market.
All right, so Mr. Bornstein, Mr. Doran made the point that plaintiffs were not locked in. 90% of their base has access. Do you agree that they're not locked in? You're muted, Mr. Bornstein.
I was being so respectful of Mr. Doran, I kept myself on mute, Your Honor. I do not agree with that point. I'll make two observations about it. First, it's not the law. This idea that you are required to have lock-in, you'll notice it's not in Apple's brief. There's no discussion, in fact, of the new Cal factors at all that we just heard from Mr. Doran in Apple's brief. This is a new argument, and it is wrong. There are 4 factors in new Cal. The one that is closest to this lock-in idea is whether there are switching costs and information costs in the primary market that impose competitive discipline in the aftermarket. We've talked about that at length. I won't go through it again, but to say that there needs to be lock-in.
He was arguing a point that was made by Judge also. So I just, let's get to, and I can read the cases as well as you all can.
Better.
So the question I have from you, just in terms of what's in front of the court, relates to the issue of lock-in.
Sure. So the evidence in the record, Your Honor, is that 63% of people who play Fortnite on iOS play it only on iOS. That's in Mr. Sweeney's declaration. There is evidence to that effect. Secondly, there are approximately 1 billion people who have iOS devices. And there is, those individuals we have shown are locked in, to use the term loosely, through the information and switching costs that I described to that device. And therefore, we can't reach those people through distribution unless those people also have some other device.
Yeah, so you want access to Apple's customer base. That doesn't necessarily mean you're locked in, given that it's what, 10% of your user base?
It's not 10% of the user base. The information that Mr. Doran was citing was daily active users, just to make sure we've got the right stat. But the issue, Your Honor, is if you step back and ask the question that is relevant to the antitrust analysis, which is there competitive discipline imposed on Apple by the existence of these other distribution options for apps generally? Or if you want to get specific and talk about games, or even more specific and talk about Epic, although I would submit you shouldn't get that specific in assessing the market.
Well, but you do agree that that's what I have in front of me now. It may not be what I have in front of me at a trial, but in terms of what I have in front of me now, it is this game market.
I don't agree with that, Your Honor. What the court has in front of it right now in Dr. Evans' declaration is a discussion of apps more generally. We don't have a gaming app market that's at issue here. We have an app distribution market on the iPhone. And to get to the point about whether the 90% or the 10% plays in here, in order for Apple to face competitive discipline from the availability of these other distribution channels, it would mean that there need to be a meaningful number of people or developers who'd be willing to give up the platform if Apple raises its price. And we know that that's not the case. Developers are not going to sacrifice 1 billion users or the opportunity to reach 1 billion users if there's a slight increase in the price or the other terms that Apple charges. And a great example of, I apologize, Your Honor.
Finish your sentence, then I have.
Sure. I was just going to say a great example is the one that Mr. Doran gave with respect to users. Yes, it's true. A 12-year-old who plays Fortnite would probably rather be using a big controller on a big screen. And yet we see that 63% of those users play only on iOS. That to me is powerful evidence of the fact that these people are actually, I don't want to say locked in because it's not the right test, but are actually committed to this platform and don't have the opportunity and aren't willing to spend the money to buy alternative platforms to use. I think that's powerful evidence in our favor, Your Honor.
The kind of a corollary on that, Mr. Doran indicated that you haven't identified any anti-competitive act. And by your statement, I suspect you agree with that. And that is because you're saying that hypothetically they could change the rate, but in fact, they haven't changed the rate. So is the anti-competitive act that they won't let someone else on? Is that what you're arguing, or what is the act that he says that Epic's not identified?
Yes, in the app distribution market, the anti-competitive acts, plural, are the technical restrictions that are imposed and the contractual restrictions that are imposed that prevent alternative distribution from being available on iOS. It's that simple. Epic right now today would like to have its own store to distribute apps on iOS. It can't because Apple has prohibited it. Flat forbid. That is the anti-competitive act at issue.
The courts have sometimes indicated that licensing restrictions, which is what those are do not constitute antitrust actions. And there seems to be great disagreement with the licensing provisions at issue here. What's your response?
I would say, Your Honor, there is no blanket exclusion to the antitrust laws for licensing. There are a variety of cases that analyze the use of patents, for example, and whether or not they are misused or whether and in a way that is in violation of the antitrust laws. There are situations in which
when that happens, aren't they coupled with some other act?
And here, Your Honor, I would say they are. I'm not sure, frankly, that is a requirement, but here I think it is the case.
Well, do you have law to support that notion? Because there is law to support the notion that disputes over licensing is insufficient.
Your Honor, I think in terms of whether or not the court is suggesting that a dispute over licensing is per se exempt from the antitrust law, I would submit that is not correct. There is, if that were the case, for example, the Ninth Circuit's decision in Qualcomm recently would have come out, it would have been much easier to write for the court since the issue there turned on patent licensing. There was instead a in-depth analysis of the nature of the restraints and the effects. And the court did not simply excuse the conduct at issue from antitrust scrutiny because it related to licensing. There is also Federal Circuit case law on the subject, and I am temporarily blanking on the name of the case because I hadn't considered the issue since it wasn't raised in Apple's brief that licensing was somehow excused completely from the antitrust laws. We can certainly submit supplemental authority if that would be useful for Your Honor.
No, it's just a question I had as I was reading the cases. Mr. Doran, any comment?
Just a couple, Your Honor. First of all, in our opposition, we do in fact, of course, speak to a party's right to safeguard its intellectual property. And we agree with Your Honor's observation that that is not an antitrust violation. I would also note, Your Honor, that counsel for Epic acknowledged that what Epic wants to do here is open its own store within the App Store. That's really what this litigation is about. That's really its objective here. And that takes us back to Apple's fundamental business model. And frankly, the contention by Epic, which it repeats, but never proves, that Epic's commitment to safety, security, and the privacy of its user information is a pretext. And that is essentially an indictment of Apple's entire business model, which has been committed to the safety, security, and privacy of its users since day one. And it also ignores the record in this matter, such as at Schmalensee paragraph 36, he notes that less than 1% of malware attacks occur within the App Store. And that is because, Your Honor, Apple safeguards the App Store and safeguards the iOS operating system to assure that its users are safe and secure when they come into this environment. Now, Epic would like Apple to let it into the App Store and would like to let Epic set up a competing store within Apple's own store. That is a fundamental disagreement with the way Apple has chosen to do business. But Apple's business model has been consistent throughout its existence. This is the way it has chosen to set up its model, and its trademark is to safeguard its users. And it has concluded that through app review and through maintaining a system where it closely controls what is on iOS, that is the best way to safeguard its users, and that's what keeps it competitive in a very competitive marketplace. And the statistics bear out that Apple's efforts have been effective. Secondly, Your Honor, counsel commented that the court should look at the 63% figure rather than the 10% figure. Your Honor, I would suggest that Fortnite has the data, and they could have put forward very precise information for this court had they so chosen. The 63% figure states that 63% of Fortnite users on iOS access Fortnite only on iOS. That does not tell us how many actively play. That just tells us that if we look at everyone who has ever opened Fortnite on an iOS platform, that they didn't use others. Perhaps they looked and lost interest. We don't know. There's no information offered. The one relevant comparative statistic, the one that tells us how Apple compares to its competition in the marketplace, is in the line before that, which states that from the time Fortnite was launched on iOS through August 13, 2020, nearly, so less than 10% of Fortnite's average daily players used an iOS platform. There is huge market competition. The market is broad, and Apple does its best to compete. But we know, and Mr. Schmid's declaration is the one piece of evidence in this case regarding the market discipline or specific testimony. And Mr. Schmid testified at paragraphs 8 and 18 in his declaration that he has been repeatedly told by Epic that Apple is the smallest piece of the pie, and that Apple has to hit Epic's deadlines or they'll proceed without them. No one in any of the Epic declarations has denied that. They too have said, we have told them they need to hit the mark or we would leave them behind and only bring them in later.
I think that's what the numbers bear out, right? Fortnite, where Epic has advised the court, what they've got 350 million users, 116 million have registered their device, so somehow linked in iOS. 10% of their 25 million daily users.
2.5 million, Your Honor. Oh, I'm sorry, I apologize, Your Honor. 10% of the 25, understood.
Right, 10% of the 25, which gives you about 2.5 million. Of that 2.5 million, maybe, I guess, 63% only linked to their iDevice. So 10% of 63 is about 6%.
I'd agree that that's a reasonable alternative reading of this paragraph. Yes, Your Honor, about 6%.
Now, 6% is still about 1.575 million people, not an insignificant number.
And Your Honor, as
I would say, right? 6% is small for Epic, but it's still 1.575 million people.
And yet, Your Honor, remember, we define the market looking at the product, not the consumer. And the product here are channels of distribution for Fortnite. And what this tells us is, and what the court has already noted, is there are many channels of distribution for Fortnite. And even if Your Honor's interpretation that you just offered is correct, and as I said, I think it's a reasonable interpretation of what's written here, nonetheless, that does not mean that these users, should they want it, can't access Fortnite through other channels. But again, for purposes of this antitrust analysis, the question is whether or not Fortnite has alternative channels. And additionally, under the antitrust laws, Fortnite is not entitled to necessarily access to every single person on the globe. They only need to have reasonable distribution alternatives available, and they have that in spades.
Okay.
Your Honor, if I may address the numbers here.
Sure.
Thank you. I note that Mr. Doran did not endorse that particular interpretation of the numbers and said, well, it's a reasonable reading. I submit that's because he probably understands that's not actually the right number here. The 63% is 63% of the 116 million people who have downloaded Fortnite onto a device or have otherwise logged into Fortnite. So we're talking about 71 million people or thereabouts based on my rough math, not 1.75 million or whatever 63% of 2.5 million is.
I wasn't saying the 63% were those linked. I was taking 10% of that because your declarations indicated that only 10% of your users are daily users. I was looking at daily usage numbers.
Yeah, it's 10% of the daily active users recently have been iOS users. That's the right calculation. But of the total number of users who are reachable and who have signed into Fortnite, we're talking about 71 million people who sign in only through this way. And again, rather than quibble too much with the numbers, the issue really is this the right framework in which to look at whether there is competitive discipline imposed here? And for all the reasons that I've talked about in terms of the non-substitutability of these alternative distribution channels, it is very much our view that the possibility of playing a game on an Xbox or on a PlayStation doesn't stop Apple from imposing whatever rate it wants, or at least a small but significant non-transitory increase in price on the distribution of apps on the iPhone. Ultimately, I think it comes down to the sort of relatively pithy point that's made in one of the declarations that you can't carry a PlayStation in your pocket. And you can't use.
You keep forgetting other devices, right?
You
can't. Forgetting Switch. I went online yesterday, and at least in the Bay Area, you can't get a Switch anywhere. You can't get it at Best Buy. You can't get it on Amazon for at least a week. You can't get these devices. You can't get it at Target. You can't get them anywhere.
But doesn't that make the point?
As if, and perhaps it's because everybody's stuck at home.
Well,
but if they're stuck at home, they're probably downloading it on their TVs.
Yeah, but doesn't it make the point, Your Honor, that you can't get these devices? There are 1 billion iOS devices out there. The possibility that some people might have the money to buy themselves an alternative gaming device, if they can find it, does not impose a competitive discipline on Apple with its 1 billion users. That's really the point. It's just not a substitute for being able to reach the iOS users that there might be some other channels. And I don't want to lose sight of the fact that we're not talking just about games here, right? We're talking about an app market more generally.
And I know that that's how you want to frame the issue. I'm not convinced that you have.
I understand that that's the court's perspective. I would just urge the court to take a look at what Dr. Evans has to say about the definition of the market on that point.
I do, and I think this is going to be a fascinating trial, frankly, because each of these experts makes a compelling argument. And like I said, there's great debate in the industry. You know, but it's complicated, because if we look at this plaintiff and this industry, walled gardens have existed for decades, right? Nintendo has had a walled garden. Sony has had a walled garden. Microsoft has had a walled garden. And so in this particular industry, what Apple's doing is not much different. Now, that's not to say that what they're doing in the general developer market is not different. They created a platform. They have some competition, but we're, you know, as we frequently are in the Northern District of California, we're in a new world. It's, you know, they don't call this the Wild West for nothing. I mean, we frequently see these kinds of new issues, especially in technology. But this particular market has frequently had walled gardens. And it's hard to ignore the economics of the industry, which is what you're asking me to do.
Well, I agree with the very first thing Your Honor said, which is that this is complicated for sure. I would respectfully disagree with the last point Your Honor made, that I'm asking the court to disregard the economics of the market in the following respect. For example,
I'm being very specific, which is that you're asking me to ignore the economics of the gaming industry.
Understood, Your Honor, and I'll try and address that very specifically. Mr. Doran made the point, and I agree with him, that just looking at the 30% is not capturing the economics of the transaction. That is just the rate. There are a number of other economic factors and terms that play in. So take a look, for example, at Microsoft and the Sony PlayStation. The economics of the transactions between those companies and the developers are entirely different, and the users are entirely different. The consoles are sold, for example, at a loss. So 30% there is very different from 30% here. I submit the court does need to look at the entirety of the economic situation in each place. And I would be remiss if I didn't make the point just one more time, that I think that restricting the analysis here to games is looking at it from the perspective of the plaintiff, when the way that one defines a market is to look at it from the perspective of the monopolist or the hypothetical monopolist. That's the test. It's not, is this particular plaintiff in a position to find alternatives? It's, is the monopolist in a position, as Mr. Doran said, to profitably raise prices above a competitive level? And that needs to be the focus, I would submit.
Well, plaintiffs always want me to define relevant markets as narrowly as possible. That helps their case. And defendants always want me to define markets as broad as possible because it helps their case. I think we can all agree, right, that the definition of a relevant market is a factual question. It's not a legal question, right? Well, and ultimately, you've got the burden of proof. On those, we can agree, right?
I agree we bear the burden of proof, and it is a factual question applying the right legal test. Yes.
Let's move to section 1. I can tell you I'm not particularly persuaded with the section 1 proffer. Mr. Bornstein, you can proceed.
Okay. Not an auspicious start for me, but I'll do my best, Your Honor. I would say, first of all, if we're talking about, and I think Your Honor is talking about the tying issue, I would say, first of all, that this is a case where per se analysis is appropriate. The arguments made by Apple that it needs to be a rule of reason test because relying on Microsoft, you're supposed to use rule of reason in software cases as though there is a software exception to the per se test. That's not correct. Microsoft expressly distinguished technical ties from contractual ties. And here, the tie of which we complain is entirely contractual. It's the requirement in the relevant agreements with Apple that developers have to use IAP for in-app processing of digital content. So per se is the right way to look at the issue. There is a threshold argument that gets made by Apple that it's not a tie because there are people who get to use the App Store and distribute their product on the App Store without having to use IAP at all if they don't offer any in-app digital content. Well, that's not, again, the way that one looks at a tie. For these specific users who choose to have and who need to use in-app processing, they have no choice. They are tied and they are required to use the tied product, the IAP. Jefferson Parish, which is the seminal Supreme Court tying case, is a good example of this. The tie there was medical operations tied to anesthesia. And the court found that there was a tie in that case where people who had operations at this hospital were required to use a particular practice of anesthesiologists. Well, there are medical operations that people undergo where they don't need anesthesia. Right? The fact that sometimes people engage in the tying market without also needing what's in the tied market, that doesn't make it any less of a tie. For people who need both products, there is a contractual requirement. That was true there. That is true here. And
Mr. Dorn.
I'm sorry, Your Honor, did you call on me?
I did.
Thank you. So Epic essentially declares IAB to be a separate product from the App Store, but without any evidence that it is in fact a standalone product. IAP is simply the function within the App Store that administers the collection of a commission when Apple is due that commission on paid apps and in-app purchases. It's never been marketed or sold separately. Epic has offered no evidence of there being a separate demand for IAP specifically as a product. And it's not at all like PayPal or Stripe in that it is an integrated element of the App Store designed specifically, again, to collect Apple's commission and distribute payment in as seamless a way as possible for the consumer, the developer, and Apple. In fact, Apple outsources the actual administrative step of the payment processing. This, Your Honor, the closest case we could find to this specific fact pattern was the Rick Mick Enterprises case out of the Ninth Circuit, which is pretty darn close because there the Ninth Circuit addressed the question of whether a payment processing function, which was a required component of a product, could form the basis for a tying claim. And the court there held it could not. And specifically, the Ninth Circuit stated that where the challenged aggregation is an essential ingredient of the system's formula for success, there is but a single product and no tie exists as a matter of law. And here, Your Honor, IAP is again a function within the App Store, within the iPhone, is an essential ingredient of Apple's formula for success. And it has been there again since the beginning as an integrated part of Apple's offerings.
Yeah, I don't, Mr. Bornstein, I just don't see this as a separate and distinct product. I see it as a very creative way to get it to 30%.
Well, may I take a shot at addressing that, Your Honor?
You may.
Okay, I appreciate that. Just to respond to the observations that Mr. Doran said about this being an integrated set of functions and an integrated set of transactions, that exact argument, the exact argument was presented by the defendants in Jefferson Parish in the Supreme Court. What they said, and I'm going to quote how the Supreme Court described the argument there. They argued, and I quote, that the package does not involve a tying arrangement at all. They are merely providing a functionally integrated package of services. And what did the Supreme Court say? They said, no, that doesn't work because, quote, our cases indicate that the answer to the question whether one or two products are involved turns not on the functional relation between them, but rather on the character of the demand for the two items. And Judge Oreck said, it says the same thing in Teradata, the same case that Mr. Doran referred to us earlier. The defendant there, SAP, said, well, we have an integrated software product. And the court said, well, I'm going to look and see if there is separate demand. The fact that you go ahead and you integrate these two things doesn't insulate you from review under the antitrust laws as to whether what you have done in integrating them is a tie. And here, the supposed integration is not a technical integration. It is a contractual tie of the two separate products. And so the thing the court needs to do is to look at whether there is separate demand. That is the right test. And it looked like Your Honor was going to say something, so I don't want to.
But so Apple Pay seems to be, to me, much more like PayPal than than when I'm in an app and I purchase something and it's tied to my credit card. And so it just gets charged to my credit card, and Apple takes its cut and gives the developer their cut. I don't.
Well,
I don't see how that's. I don't see how the transaction of being, of divvying up the payment is a separate and distinct product.
So to address the first point, if I'm getting an Uber, right, my credit card is in there already, and I get my Uber, and it seamlessly goes through, and I don't have to do anything else. It's just like IAP in that respect, except Uber is not required to use Apple services. Why? Because Apple doesn't make it. We can speculate about why they have chosen or not chosen to extend the tie that far, but they have chosen not to. As to whether it's a separate product, this is something Dr. Evans does address, Your Honor. There is, in the first instance, a transaction between a consumer who is looking to obtain an app and the developer in the App Store, facilitated by Apple, to obtain the app and get it downloaded onto the device. That is a transaction that Apple facilitates through the store because Apple requires everyone to go through the store. Whether a year from now, that person wants to upgrade their fitness app from the free version to the premium version and get more data about their daily run, or whether somebody wants to upgrade their subscription to a particular periodical or news source, that is a separate decision made at a separate point in time, which is a transaction that occurs between the user and the developer of the app. So to take Fortnite as an example, if a Fortnite player a year from now, after downloading the app onto, well, it can't right now on the iPhone, but after downloading the app onto his or her device, wants to make a purchase in the game, that is a relationship that the app has built with the consumer. It should be run by the app and the consumer, the customer service, the refunds. They should all be managed between the developer and the consumer, instead of having Apple intermediate down the line in this entirely separate transaction.
All right, a response.
Your Honor, first of all, Jefferson Parish and Teradata both did deal with separate products and products that were offered separately. And here, IAP has never been offered separately. It's never stood alone as a product. It's never been offered as a product, and there's no evidence of a separate demand in the market for it. So it's utterly distinct from the tying of a second product to a first. Rick Mick is the case that really is on point here, Your Honor. That was a motion to dismiss case where the court held that the inclusion of a payment process within a product was not a separate product. And that's exactly what we have here. And just as the court could find that on the motion to dismiss stage there, so too this court can conclude that this is not a separate product. We talk about, or Mr. Bornstein finished up by talking about the timing of the transactions, but Mr. Schmalensky addressed that directly in paragraph 6 and paragraph 59 of his declaration, where he said there's no economic basis to distinguish between in terms of evaluating whether something is a separate product or not, from an initial transaction to a subsequent one. At the end of the day, Your Honor, I'll take no more time on this because this is simply an element of the App Store, which is an element of the iPhone. It's a fully integrated product. It is not a separate product with a separate demand in a separate market.
Okay.
Your Honor, may I be heard on the subject of separate demand, which has been raised a few times now?
All right, briefly.
Sure. I will just point out we have in our papers, I can refer the court to it, extensive evidence of separate demand for the payment processing checkout function from the App Store. There are, first of all, the apps that Apple doesn't require it to be used for, like Uber and other physical apps. There are the other app stores we've identified on Android, like Aptoid and SlideMe and others, and Epic Games itself that doesn't require the use of an affiliated IAP. Those are in footnote 45 of the reply declaration from Dr. Evans. There is evidence that when Epic did the hot fix, over 50% of people chose to use direct pay. There was user demand for that product, separate from Apple IAP. And Apple disclosed in its papers for the first time that there have been thousands of instances in which developers have attempted to introduce a separate payment processing service in an app, and Apple has rejected it. There's clearly demand from both developers and users for something separate here.
On that last point, separate from the antitrust specifically, you've mentioned, Mr. Doran, multiple times that, and it was my understanding that Apple uses third parties to address the payment function. One, am I correct in that? And two, does Apple use, or would they use other providers, let's say such as PayPal, if PayPal gave you your 30%?
No, Your Honor, because IAP involves a number of other elements. For example, IAP deals with foreign taxes, it deals with foreign withholdings for the developers. And as to the users, when a transaction goes through the App Store, then Apple's commitment to the safety, security, and privacy of its members kicks in. And for example, the payment information provided to Apple by users is never shared with the developer. And there are parental controls in place so that parents have an opportunity to make sure that their kids aren't buying too many skins or V-Bucks on Fortnite or whatever another parallel may be. It also facilitates family sharing of purchases. It facilitates the generation of historic records of purchases. So there are a lot of elements of it that are part and parcel and really integrated into the operation of the App Store. And so it's far more than just one small administrative step. There's a lot of code and a lot of functionality, but it's all, again, fully integrated into the App Store and has really been there since the beginning.
So your expert opines that there's no separate demand for IAP. But as Mr. Bornstein correctly points out, once in that short period of time between when Fortnite was taken off the Apple platform and the dual functionality that had been placed on there by Fortnite was available. 50% of the people did in fact use the alternative mechanism. Doesn't that undercut, in fact, your argument that there is no demand?
No, Your Honor. What it seems to evidence is that when people can purchase V-Bucks for $7.99 instead of $9.99, half of them will elect to pay $7.99. I think what's probably most enlightening about that statistic is that half of the people prefer to stay within the App Store and within IAP because they trust Apple to protect their safety, security, and privacy.
Okay. It's the last topic that we haven't really talked about in terms of the Section 1 and Section 2 arguments. Mr. Bornstein raised it. I don't know if you want to raise it or not. Mr. Doran, is the rule of reason analysis that Apple identified in its brief.
Your Honor, I think the distinctions that Mr. Bornstein draws in order to avoid the holdings in Microsoft and then the further discussion in Qualcomm of the need to do a deep fact analysis and therefore that the per se standard really has no place when dealing with the tech platforms. The fact that there are contract provisions involved as well as integrated technical elements, we don't think changes the analysis. I think, frankly, the fact that one would need to sort out between what is the nature of the product, how integrated is it physically into the platform, is it in fact only a contractual limitation, or is it also a technological single product? If one were dealing with what is clearly two separate products, there may be a discussion to have here, but here there's a threshold question of whether or not there's just a single product. We believe that's not even a question. As Your Honor noted, it's really a clever argument to dispute the 30%. So this is clearly a rule of reason situation. Having said that, we also think that with Rick Mick, it shows that it's a situation that is easily resolved in finding that this is a single product that therefore cannot form the legal basis of a tying claim.
Okay. All right, let's go ahead and shift to the other elements. This portion of the argument, Ms. Forrest and Mr. Boutros, will be much shorter. Unlike junior people, I don't feel so bad given that you all get lots of time in front of courts, and so you don't need additional argument time. I always feel bad when I have a young person who is given the last motion to argue in front of the court, and I'm out of gas and just say, no, I'm not going to hear argument, and I feel bad about it. But with you two, I don't feel that bad. I actually didn't read all that much new in the additional papers with respect to the remaining elements. So that's why I said I don't know that this part of the argument will be that long at all, given my admonition to you in the beginning not to repeat. But there were a couple of new things, but really not much. Ms. Forrest.
Thank you, Your Honor. What I'd like to do is to focus on a few things that we did not point out in our papers that are uncontested by Apple in its papers as to the irreparable harm that is real, that is actual, and that is happening today. And these are things which were set out in the declarations, the opening declarations of our witnesses, and they were not contested by the Apple witnesses. So I think that it's important to point these things out. One is that the iOS business for Epic has been shuttered. And that there are all kinds of statistics in Mr. Sweeney's declaration as to the declines. That is real and that is happening. In addition to that, we have a shuttered series of businesses that are event businesses. These are the events that Epic puts on through the Fortnite app for concerts that we know the iOS users want. There were 2 million of them who attended the Travis Scott concert in April of 2020. We know that there is iOS demand for the other concerts and events in terms of ESPN exclusive performances, for the Discovery Channel exclusive performances, for the social justice conversations. Those businesses have been entirely shuttered for Epic. In addition, and none of that is contested. There is no contest to the diminution of goodwill and to the reputational harm. No contest to that. There's also no contest to the damage that is flowing to the Unreal Engine. In fact, Apple actually concedes that the Unreal Engine is having an existential crisis, and it actually puts forward a Unity as an alternative development platform engine, acknowledging that the Unreal Engine is going through an existential moment. Having competition go from 2 development platforms with Unreal Engine and Unity down to 1 is not an answer. There is absolute irreparable harm to Epic's Unreal Engine business. It's got thousands, hundreds of thousands of developers who have millions of licensees who are dependent upon these engines, and this is going to shutter that business for Epic. That is not contested. It is also not contested that the other ways in which Apple is threatening now to extend its collective punishment through the withdrawal of tools and the ability with the development programs to allow the other Epic properties to function, that is also going to potentially shutter those iOS businesses for Epic. So there is an across the board amount of collective punishment against all of Epic's iOS businesses which have been shuttered, and where Apple is not contesting those facts. Your Honor, I'd also like to talk about one argument in this regard that Apple raises with respect to whether or not the preliminary injunction context is a context in which the case law, which suggests that the breach by Epic of its contractual relationship with Apple gives it the right not to have to deal any longer and to terminate at will its contracts, and whether or not it withdraws and impacts the equitable ability of this court to provide injunctive relief. A couple of points on that. What I'd like to say first, Your Honor, is the great irony that it would be if it in fact were the case that the same act that for the Supreme Court cannot be held as a basis for denying recovery at the end of a case could nevertheless allow for the complete destruction of a business during a case. It has got to be.
The argument with respect to that particular topic really does hinge on the fact that you succeed, right? And it goes back to the likelihood of success on the merits. So it's circular. You are irreparably harmed and cannot be damaged by being irreparably harmed because you're going to succeed, but you only succeed if. I mean, it's a circular argument. So it hinges on the first part of this debate.
It does, Your Honor. If Your Honor does not find a likelihood of success on the merits, then a PI will not issue here. That is certainly true. What I am suggesting is that to the extent that the balance of equity element has been argued by Apple to not apply to us, that we have no equities based upon our conduct, that is not what the Supreme Court case law holds. It's not what the principles of those cases hold.
Well, I certainly agree with you. I mean, I certainly agree, right? Balance of equity is one of the things that we look at, but it is a separate and distinct element from likelihood of success. And other than the fact of you arguing, and I still separate Unreal Engine and Fortnite and the other games. The argument with respect to Fortnite your argument is really just we're going to win, and so therefore we get the balance of equities. It's nothing more than that.
Your Honor, it's also that there is extraordinary consumer harm that is happening right now, and
that's public interest. And again, you know, I don't conflate them. That is, I am required to do a separate analysis for each. And what happens with the public is separate and distinct than what happens with the parties. And those need to be evaluated separately.
I agree with you, Your Honor. And my point for the balance of the equities is that to the extent that you have an entity here, Epic, that is actually ceasing to comply with an anti-competitive provision, which we believe the certain provisions of the Apple contracts constitute, that those equities are in our favor, and that when consumers are harmed by the fact that there's retaliation for that lack of compliance with an anti-competitive provision, that those equities are also in our favor. I agree with you that the harm to the public actually hits on multiple factors, but it also hits on balance of the equities. I can, Your Honor, if you would like, for a moment, talk about Apple's arguments that there are security issues that somehow take away our arguments on the public interest.
I think that's a good argument to be had. I would just say, you know, there is some case law with respect to, well, first of all, I should back up and say, in general, we don't have federal courts issue injunctions just because parties get into a contractual dispute. And in many ways, part of this is all a contractual dispute over the licensing fees that Apple is engaging, in addition to the antitrust issues. But generally, we don't have federal courts do that. There are instances, though, where federal courts would have might issue orders to keep the status quo in situations where a company or business is going to go out of business. That's not the case for Epic. No one's entitled to make billions of dollars. There was a calculated decision here, and as the numbers went through these with Mr. Bornstein earlier, the iOS share of the pie for Epic is pretty small relative to everything else. So we aren't in a circumstance where some business is going to go out of business. Really, to the extent that there's harm, it's the public interest, which is different. So it was interesting to me, the declaration of Mr. Sweeney. Mr. Sweeney's declaration did not, in fact, indicate that there was nothing in the Unreal Engine that violated effectively paragraph 3 of the license agreement. What he said is that Epic doesn't engage in malware. Well, great to hear. Glad to hear. I don't think anybody, any reputable company should be engaging in malware. But he didn't go further to say that there is nothing in there that interferes with Apple software or services, that there's nothing in there that any hidden code that doesn't provide or unlock or have additional features, that there's nothing in there that is attempting to hide or misrepresent or obscure features or content. Why is that? And is there?
Well, Your Honor, there are a couple of facts about the Unreal Engine that make that argument that it could somehow act as a Trojan horse really a total straw man. Number one, the Unreal Engine is not consumer facing. This is a development platform on which app developers make their own apps. That's what this is. The app developers are the one who are making the apps that then go into the App Store. It's a development platform. It's not consumer facing. And that's set forth in the declaration of Mr. Grant. It also is, an app where there's no a development platform where there's no IAP. This is a completely irrelevant argument to the Unreal Engine. The Unreal Engine is a development platform that is used by developers all over the world for all kinds of different industries, not just gaming, but it's used for electronics, it's used for medical devices, it's used for space, it's used for airplanes. And it's those developers who are determining what the functionality is. So the idea that it could act as some sort of Trojan horse to Apple is misapprehending the Unreal Engine from start to finish.
Yeah, I think, and let's see, Mr. Boutros, why don't you go? You can respond on this one. I'll come back to you, Ms. Forrest. But I think that Apple's, the sky is falling down approach on this topic is a bit overblown. I did find the fact that that Mr. Sweeney was a little bit obscure in his declaration to be interesting, but I also don't think that Apple's really on solid ground in some sense that that everything's going to explode because the Unreal Engine's allowed to operate.
Let me start with that, Your Honor. Thank you. First, as I think the court was alluding to this, put aside whether the Epic tries again to cheat and to sneak in a Trojan horse, which really went to the core foundation of its agreements with Apple, bypassing the app review process. Let's assume it doesn't try it again. But there's also the problem of inadvertent problems and things that they might do. And what they're trying to do here is go after the entire business model. If this court were to issue a preliminary injunction, Mr. Sweeney is trying to be the Pied Piper of other developers. He's trying to bring everybody along. And if this court were to say that others could do what Epic did here, which is cheat, breach its agreement, sneak in software to bypass app review and IAP, others would do it too. And that really goes to the core of the system. So it's not just Epic and Unreal Engine that we're concerned about. And that is a fundamental core of the business model. And Mr. Bornstein basically again admitted that Epic wants to take down and have this court at the beginning of the case issue an injunction that would go to the core of Apple's business model and unravel it and be a green light to other companies. And that would be very dangerous. We do take the security.
Let me ask them. If I leave in place, if I make the injunction, the temporary injunction pending trial, the same as the TRO, then the public knows, right, that you breach the agreement, it's fair game to kick you off the platform. And really, and my sole focus with respect to the Unreal Engine has been that it was a separate contract, and the harm to the public was incredibly high, especially when there wasn't a breach of that particular contract. So doesn't that shield Apple in the way that it needs to be shielded for purposes of this short period going to trial?
Let me go right to that, Your Honor. First, as Mr. Schiller points out, and he was one of the founders of the App Store, it's extremely important for Apple to be able to terminate affiliates. And this is a practice. The court in its TRO order invited additional evidence on this point. And as he said, that even since 2016, Apple has terminated affiliates thousands of times to protect consumers and privacy and data security. And on this point, Your Honor, let me just go right to the new evidence on Unreal Engine, because I understood the court's concern there. First, we now know that Epic International is not some innocent party, as they told the court at the TRO stage. Paragraph 68 of Mr. Schiller's declaration states that, without dispute from Epic, that Epic International is siphoning off illicit payments from the overseas Fortnite users through the hotfix. So they're participating in the scheme, the cheating that happened. Secondly, Epic International, by doing that, itself is breaching its agreements. It's breaching, as the court knows, in the guidelines, which are incorporated into the developer license agreement, it precludes cheating the system and dishonest behavior. That's what Epic International is doing. It's profiting from the wrong. In addition, as Ms. Forrest alluded to and didn't dispute, we've shown that Epic International is controlled by Mr. Sweeney, Mr. Penwarden, who submitted a declaration saying he's basically in control of Unreal Engine, even though he's the chief engineer for Epic Games. Epic Games, in responding on the sign-in with Apple dispute, which is all the correspondence before the court, admitted that Epic Games and Epic International, Unreal Engine are all tied together, and Epic is managing that. And so it's a different record, Your Honor, and I think it goes to this retaliation point. Apple wasn't retaliating against Unreal Engine. It was doing what it has done thousands of times, was protecting its ecosystem. Yes, Your Honor.
I understand that, Mr. Boutros, but I can also say that every time Apple has a breach of contract with one of its developers, they don't call you into court to defend them, right? This is no small case. And all the developers know that. This is not a small case. So if someone would dare to do what Epic has done, the likelihood that they are going to get shut down and shut down hard as a developer, as you say, your guidelines indicate, it's in there that the developer, not just the contract, but the developer can be shut out, seems to be a contractual right. But this is not an ordinary case. And I think you would probably agree with me that this is not the ordinary case. And so when we have extraordinary cases, judges try as best we can to keep the playing field as level as possible with as little harm as possible so that we can, in a objective way, move forward. Now, one of the things that occurred to me, having read that paragraph, and I would like a response on that topic, Ms. Forrest, is whether or not to order the payment of the 30% that is being collected by International, or has been collected by International, to Apple during the pendency. Thoughts?
Your Honor, I can let me respond to that question first, which is that if we lose this preliminary injunction in terms of IAP and are not able to have the Epic Pay be part of a Fortnite app that is available on the App Store, and Your Honor finds that, then putting the 30% that is coming in from the small number of Apple users who are still in existence, which is less than 25% of what they originally were, then that can go into escrow. It can go wherever Your Honor directs. Yes. You tell us where to put it and it will be put there. Let me just also respond to the fact that Epic International has been receiving those payments. It's been receiving them simply as an administrative matter, only as to foreign transactions. It's not been receiving them as to all transactions. So the idea that it is somehow siphoning off illicit payments, I think, is using hyperbolic language to mischaracterize what is occurring here. In terms of the Epic International and in terms of all of the other affiliated companies with Epic, because it's not just Epic International, it's not just the Unreal Engine. We focused on those, but there are others, and those are set forth in Mr. Grant's declaration. And the facts as to those are not contested. They are not integrated agreements. They are not agreements that can be terminated at will. Certainly they cannot be terminated at will by a monopolist who has different kinds of law applicable to his or her or its conduct. They are entities which have got different start dates. They're entities that have different products. They're entities that have different team ideas.
I don't think what you've done, though, with respect to anything other than the Unreal Engine, is provide the same kind of compelling case with respect to the damage in terms of public interest.
Your Honor, you are correct that we did focus on the Unreal Engine because there's only so much that one can actually sort of evidence put into the record in this truncated proceeding. However, we do have evidence in the record relating to House Party, relating to a number of the other properties, including Life on Air, K-Raw, Psionics, and the Epic Sweden property. And those are all set forth in the grant declaration, paragraphs 5 through 12. So there is evidence that they will be impacted if the tools are taken away, the same tools and their program developer agreements are cut off, just as with Unreal Engine, they will be severely impacted. Those facts were in the opening declaration of Mr. Grant, and they were not contested by Apple. If I could, Your Honor, I could move on to a couple of other quick points that were raised by Mr. Boutros. One is the choice of the business model by Apple, and I would just suggest that a monopolist cannot choose a business model and stick by it without consequence when there are unlawful contractual provisions that are securing it.
Do you have a perspective yet as to what period in time, at what point in time did Apple become a monopolist?
Your Honor, I do know that as of 2018, when Epic itself went on to the iOS platform, that's the data that we have. Apple was already in a monopoly position. It required us to.
So when you're claiming, other than the, you want me not to think about the gaming industry, and I think it's obvious that in 2007, nothing existed. And in the 2007, 2008 early years, Apple created something. And now it's a ubiquitous platform. So they've gone from being a non-player to an innovator. And at some point, there's a claim that they became a monopolist.
Well, Your Honor,
even though, right, rates haven't changed. So do your experts have an opinion? Because we're supposed to, from your perspective, only be thinking about all the apps or the entire ecosystem. At what time, when did the shift happen? What happened?
Your Honor,
maybe you can't answer that question yet. I don't know, but it seems to me.
I can answer part of it.
Question.
I can answer part of it, which is that there are companies which actually have innovative products and achieve a monopoly position, as we started off today, with business acumen and with innovation, that they don't unlawfully.
Excuse me, Your Honor. I'm sorry.
I thought so. I'll tell her. Thank you. Ms. Forrest, you need to slow down.
Oh, I'm sorry.
Our court reporter, you can't see her on the platform, or at least I can't see her on the platform, but I generally, we've been together for so many years. I know when cadence, when the caffeine kicks in.
That's the cry for help. I get it. Okay. Let me just say that there are instances where there is a company which has an innovative product where they have a monopoly position in that product almost immediately. However, they don't have an unlawful monopoly. The unlawful monopoly comes along when there's monopoly maintenance conduct. What we have here and what we know we have here from Apple as of the time that we entered into our contractual agreements, which were contracts of adhesion, there was no
and that's okay with you, right? You're not opposed to contracts of adhesion because you generate them, right?
Well, the Unreal Engine, for instance, actually has negotiated contracts.
Seriously, Epic Games is not opposed to contracts of adhesion, are they?
There are certain contracts of adhesion that Epic Games has, correct.
Okay, go ahead.
What I'm suggesting is that as of 2018, when we entered into our relationship with iOS, there were no alternative app stores. And there was no alternative to IAP. It was a monopolist at that time, and it has sought to maintain its monopoly throughout that time. You look like you're about to say something, so I don't want to interrupt.
Go ahead.
Okay. So that, I think, is our view as to when did it start? It started at the beginning. When did it become unlawful? That becomes a more complicated question. It became unlawful as to us as of 2018. When did it become unlawful to the point where we could no longer actually abide by the contractual provisions? It was after our ability to even try to negotiate with Apple, which we did. We did try, ran out. And only after that, in the summer of 2020, did we sue. And if I could, Your Honor, I'd go through just a couple of the other points that were raised by Mr. Boutros, which is that he said that we had been a cheater and that this was an act of sabotage. And I want to address that because that goes to both the public interest and the equitable arguments that have been made, as well as whether or not the court would feel persuaded by the irreparable harm. We are not cheaters. We are not saboteurs. There is uncontradicted evidence in the record that was put in the opening declaration of Mr. Grant and Mr. Sweeney relating to the turning on of the payment service. We call this the hot fix. And the word hot fix seems to have this negative connotation, but let me just say a couple of words about.
I don't know that it has a negative connotation. You were not forthright. You weren't. You were told you couldn't do it, and you did. You know, there's that old saying, a rose by any other name is still a rose. I mean, you can try all you want. You can try all, but you're not going to convince anybody that you had something in there. You tried to have Apple approve of it, good or bad. They said no, and you did it yourself. It's self-help.
What I want to say, though, is that we have used hotfix hundreds of times in the
Lots
past.
of people use hot fixes. That's not the issue. That's not the issue. The issue is that you were told and you knew explicitly because of your contractual relations that you could not have that. And you did.
My point is
really pretty simple.
I understand, Your Honor. My point is I want to connect that to the alleged security issues, because Apple ties the hotfix to sabotage as if it's tied to security. Once it's understood that hotfixes are commonplace, that they were used hundreds of times in the past, that Apple never complained, they're not a security issue. And indeed, no security.
What the security issue is that you did something, you lied about it by omission, by not being forthcoming. That's the security issue. That's the security issue.
Your
Now,
Honor,
it could have been, you know, as you say, it's not malware. But let's not debate a point that, I mean, to tell, you know, there are plenty of people in the public who consider you guys heroes for what you did, but it's still not honest.
Your Honor, what Apple tries to do is it tries to tie the hotfix to the idea that we have made the ecosystem insecure. After a full month with this code, they know that there is absolutely no security or privacy issue that is real. They also.
Where did I start this discussion? I told Mr. Boutros I thought that they were really overblowing their claims. So yeah, no argument there. But don't try to convince me that you were forthright when you weren't.
I understand your position, Your Honor. And I do know that Your Honor has also read our papers thoroughly on this point, so I'll leave it. Can I talk just a little bit about the security point, or have you heard enough on that as well?
No, I don't think there are particular security issues. Mr. Boutros.
Yes, thank you, Your Honor. If I could just back up for a second in terms of the preliminary injunction standard. I think the court was just getting to a point I was going to get to. Epic wasn't honest. This court's sitting as a court of equity. There's no dispute that Epic needs to meet all 4 preliminary injunction standards to get an injunction, a preliminary injunction. Ms. Forrest just admitted they must show likelihood of success on the merits. The Garcia v. Google en banc decision says that they must meet that standard. They haven't met it. As Mr. Doran demonstrated, and the court mentioned the Wild West, this is the frontier fringes of antitrust law. They can't possibly show likelihood of success. Epic needs to also show irreparable harm to itself before we get to public interest or balance of the equities. It has failed to do so, both as to Fortnite, for the reasons the court held in the TRO, self-inflicted wound, a problem of its own making. They could have just kept performing. They just wanted to get more money and get the platform for free.
You're repeating yourself. Anything new?
Yes, let me just make the new part, Your Honor, that on the public interest focus, it's Epic that's injuring the public interest with respect to Unreal Engine and third parties. Epic is by not complying with the contract, it's Epic that triggered the contractual rights, and they could fix that with a keystroke. So when you look at all of the factors,
Well,
they
it
must
doesn't
meet them
matter at
all.
this point. Are you telling me, I understood that Apple had said, and it really could be just hypothetical, because I don't think that they would agree to go back on, but Apple said, look, even if you agreed, we're keeping you off for a year, period. Has their position changed?
Yes, Your Honor, the standard language from the usual letter in this context was included in the Unreal Engine letter, but Apple's willing to, since this court is involved in the court supervision, if Epic would just come into compliance, it can free Fortnite, it can free Unreal Engine by just complying, paying what it owes, and we have a trial and summary judgment and proceed. And that will protect the public.
What about this? What if that 30%, well, I was going to say, what if it went into some escrow account?
That would at least address.
It's kind of, we're talking about billion-dollar companies. I don't know why we would do that, but other than to give each side maybe a little bit to hang their hat on. So what if I said that? It goes into
Your Honor,
escrow account.
Yeah, that at least addresses part of it. It's the fact that Epic International is part of the scheme to take these profits and take it all. But there's also the 30% that Epic is taking now. It's Epic Games is taking as well for U.S. sales. But it really goes to this point, Your Honor, just as a legal matter. The same rationale with respect to Fortnite applies to Unreal Engine. Epic can cure it in a second. Just go into compliance. If it's not about the money, pay Apple the money they owe Apple. And then Unreal Engine, Apple's willing to let Unreal Engine and Fortnite back on the system. That's the proper approach here. And what I would suggest to Ms. Forrest.
What?
Oh yes, Your Honor.
But respond to my question. If will Apple let Fortnite back on? And would Ms. Forrest, Epic Games, agree to go back on without their own payment option, but all monies that flow from that go into a escrow account pending resolution of this lawsuit? Yes or no? Or you don't know? Mr. Boutros? Yes.
So if I'm understanding, yes, Your Honor, if I'm understanding the court's question, if Epic were to disable the hotfix, their own payment system, go back to using IAP, the 30% were to go into some sort of escrow account, and Unreal Engine likewise would come back on. That would address a lot of the issues. I would have to ask my client about it, since it is a significant thing, but it does at least start to address the issues. There's just no way we can have Fortnite stay on the App Store, defying IAP, defying app review, for the reasons the court already had ruled. And with respect to Unreal Engine, it seems like it's easily fixable by Epic.
Ms. Forrest?
Your Honor, we would not agree that a scenario under which we are required not to have consumer choice and competition on payment options.
I don't need a long answer. Yes, so it sounds like no, you're not interested in that.
We're not interested, and we would also say, Your Honor, just briefly, that the cases that we've cited, the Supreme Court cases, say that this court should not give its assistance to unlawful provisions by monopolists, and that therefore we would be agreeing and trying to comply with unlawful provision.
Yeah, I didn't buy that argument before. I'm not particularly impressed with it now.
Can I say a couple of things just in response to things Mr. Boutros had said earlier?
Quickly. Briefly.
Okay. I'll try not to be too quick. One, that there is irreparable harm to Epic. Epic's iOS business has been shuttered. And two, monopolists, when they say that
there's no case law that says that, my billion-dollar company is, is losing some millions, and so therefore that's irreparable harm. There's no case law to support that.
No, there's lots of case law that says that when you've got a diminution in goodwill, which is exactly the destruction of a business, that is precisely the time that there should be a preliminary injunction. It doesn't have to be all aspects of a business. It is this business.
Your goodwill is probably in some ways increased. So again, maybe for some people less goodwill, but for other people, lots of goodwill. And it certainly, and your marketing campaign has been lauded, given your conduct. Okay, what else?
Your Honor, if I could just address one more point on the Unreal Engine. I don't know if I misheard Ms. Forrest suggest this, that somehow it's been destroyed or it's going under. The evidence, they had the burden to bring evidence. Mr. Penwarden talks about a few dozen complaints or concerns, gives 3 or 4 examples. And I just would suggest it's a extreme form of relief they're asking, having breached the agreements. They could cure the problem themselves. They didn't bring forth evidence of the kind of harm they're suggesting to the public and to third parties, and they could cure it themselves. And Your Honor, I understand the court's sensitivities about affecting other people, but it's this, I'll end with this. It's the same analysis as to Fortnite. They could fix it in a second. They're not claiming damages. They have publicized their campaign. If anyone's getting wind of what's happening, it's because they've been on this blistering ad campaign, and they formed a group last week of other developers to expand it. So they don't need this court's emergency help. They have the keys in their pocket to free Fortnite and Unreal Engine. Thank you.
Your Honor, on Unreal Engine, let me just say, because I think the evidence has been completely mischaracterized, there is unrebutted evidence in the record in both the declarations of Mr. Penwarden and Mr. Grant that there are hundreds of thousands of developers whose platforms are at risk. We say that Apple, we believe, will stop accepting Unreal Engine apps that are built on that platform as of 2021. They will be then destroyed. We have numerous, dozens and dozens, and that's set forth in the Penwarden Declaration, of instances where developers are saying that they are concerned, and we have millions of users who are reliant upon those applications. All of that evidence is in the record. This is not a handful of 3 or 4 examples. We have got millions of people who will be directly affected. Can I say one more thing on?
Let me just say on that last piece, that if it is not uncommon, as you all will know, that if circumstances significantly change, that motions and requests can't be renewed. All right, last issue. You said you wanted to say something else, Ms. Forrest.
The last thing I would say, Your Honor, is there's been discussion of a publicity campaign. All I would say with that is, when you are taking on the biggest company in the world, and you're taking it on where you know it's going to retaliate, you don't lie down in the street and die. You plan very carefully on how you're going to respond, and you try very hard to keep your head above water. And that's what we've done here. Yes, there's been a publicity campaign. We took on the biggest company in the world that is fighting us hard, and we knew that.
Your Honor, may I address that just briefly?
There are other people who are taking it on. And one of the questions that you never answered after our last hearing is what happened that made this so urgent. The topic related to the App Store is not a new topic. I tried a case over the alleged monopoly that Apple had with respect to iPods. It was so old by the time I got it. It was so old by the time we tried it that we had to bring iPods into the courtroom because no one knew what they were. And in fact, I'd forgotten you have to put headphones in. I tapped the little button expecting to hear the music, and nothing came out. Until then I remembered, oh, you need headphones for these things. So we tried that case. And Apple won on the security issues in front of a jury. So this isn't just some judge. This was a jury who made that call. And there is active litigation happening in the Cameron case and in the Pepper case on this topic. So, you know, the Epic can choose to go out on its own, that's fine. But it's not as if others aren't taking Apple on.
I understand. Can I just address the idea of why did we do it? And just very, very briefly, we have heard in this case and in the Apple's papers that there is no separate market for the App Store and IAP. If we had brought a declaratory judgment argument that said that there were separate products and they were tied together, what you would hear from Apple is that they are integrated, that there is no separate demand. What we did when we released the hotfix is we showed that there was separate demand. We did proof of concept. We eliminated Apple's ability to say that there is no separate product. We showed that there is. That gives us something that we would otherwise have been unable to have. We had it for 6 hours, but by golly, those were an important 6 hours. We showed that consumers want the choice, that they want lower prices. We did the hotfix because we had to.
It's good evidence, but it doesn't mean that you can't go back into compliance. I mean, you can. And, you know, which brings me to another point, which is that I think personally this case should be tried to a jury. And I want everybody to think about that. And the reason I say that is because individual judges don't have and aren't the be all and end all. I can tell you that circuit court judges don't give district court judges lots of discretion when it comes to factual matters, despite what it is they're supposed to do. They actually don't care very much. They're going to decide what they want to decide. You know, I mean, I think we've seen time and time again, district court judges can make, we can write orders that are hundreds of pages long with all sorts of factual findings, and the appellate courts are going to do what they want to do. But when it comes to juries, they are much less likely to ignore the factual findings of jurors. And you're going to go through this whole process. It's going to cost a lot of money, time, and effort. And as we've noted, these are important cases and they're on the frontier of antitrust law. You might as well find out what people really think and want and take that to the Court of Appeal. Because I know that I'm just a stepping stone for all of you. Whoever loses is going to take it up and say everything I did was wrong. That's what litigators do. I understand it. There's no hard feelings. That's the job. But I think that it is important enough to understand what real people think. You know, do these security issues concern people or not? Is there, is the concerns of the developers incredibly important? I think many people would think that it is. But I'll have you chew on that because I do think that this is something for which jury insights would be important. Otherwise, it's just one more judge. Okay, so with that, let's talk about trial schedule. Federal judges, in case you didn't notice, are a little bit busy. I don't want to try two cases. The difference between 6 months and 8 months and 10 months in our life is not a big difference. So I'm inclined to try both cases at once. So you should plan on that.
Your Honor, and may I say one thing just to make sure that when we talked earlier about the no amendments to the pleadings, that we didn't lose sight of one thing, which is our answer is due tomorrow. We are answering the counterclaims in order to make sure that that Apple understands exactly what our defenses are. However, we are going to move to dismiss under 12C 2 of the counterclaims that actually try to, or 3 of them that actually try to expand the evidence beyond really a breach of contract. We actually don't disagree that we have breached a contract if you find against us on the antitrust claims. That's not going to be an issue that's going to require a lot of a complexity in this case. If we are wrong, then we have breached the contract. And so we will try to get rid of, we believe we've got very good legal reasons to get rid of the conversion claim, the prospective economic advantage, and the separate covenant of good faith and fair dealing.
So I think it's a good motion with respect to conversion. And frankly, what I'd like to do is I would like for you all perhaps to meet and confer. You can file it tomorrow. Your deadline's tomorrow. It's probably already written. But perhaps after it's filed, you all can meet and confer. California law is pretty clear that in a conversion claim, especially when you're talking about money damages, you have to be able to trace the money. So if someone has, in the old days, a set of gold coins, you could have a conversion claim. But you really have, and I've actually written on this, you have to be able to trace. You cannot bring a conversion claim in your run-of-the-mill contract dispute. So you really should be able to address that without motion practice. And if you don't, is fine. I'll probably cut and paste from a prior order and dismiss it. I mean, you'd have to have some very good arguments to claim that somehow you've got conversion here. I don't know what the arguments are for trying to dismiss the implied covenant of good faith and fair dealing. There's always an implied covenant of good faith and fair dealing. So what would be the basis for moving to dismiss that claim?
Because, Your Honor, it's not a separate claim from a breach of contract claim. If there is a contractual obligation directly on point, then one does not have a separate breach of covenant in good faith and fair dealing.
Under California law, you can plead in the alternative. We let people do it all the time.
They're not asking for an alternative reading, Your Honor. They're saying that there's a direct contractual provision that has been breached, and then they're also asking for a breach of covenant of good faith and fair dealing. That's simply to bring in intent. There's no reason to bring in intent. We're conceding that if we're wrong about the antitrust claim, there's been a breach of contract. We're conceding that. This is not a situation.
I'm sorry, Your Honor. Excuse me. This is Renee Mercado.
I'm sorry.
Counsel needs to slow down.
Let me repeat. I apologize, Ms. Mercado. That when there is a contractual obligation that is directly on point, then there is no separate covenant of good faith and fair dealing claim that lies. And we believe that that is exactly on point here, and that is only being asserted in order to bring in additional evidence of intent. This is a simple contract issue. It gets really, it's the opposite of the antitrust. If we lose on the antitrust, they win on the contract. It's not really going to be and shouldn't be a complex second trial. In terms of prospective interference with prospective business relations, again, when there are contractual obligations directly on point, that doctrine is inapplicable, and there's good California law on that as well.
Mr. Dorn.
Your Honor, obviously we disagree. We have pled the claims in the alternative, as is our right. And obviously we'll look to see what their motion has to say, but we disagree with that characterization of the law and with our rights as the cross complainant. We believe that the claim should stand.
Well, I suspect that you'll follow your motion. 35 days notice is a standard. Don't expect oral argument, and I'll probably just issue an order. I mean, and you certainly should not stop. That is, you need to get going here because time is going to be short and of the essence. All right. So with respect to the schedules that have been proffered, thoughts?
Your Honor.
Yeah, if you want to say something other than what's in your papers.
Your Honor, what we would just urge the court is for the shortest schedule possible, particularly if there's not going to be any injunctive relief on one of our bases or either of the bases, whatever Your Honor decides, then it's going to be particularly important that we get to trial as quickly as possible.
I agree. And just so that you all know, I frequently set trials where there is an injunction in 6 months. So your stats are interesting, but they're not my practice.
Your Honor, I'm sorry. I thought Ms. Forrest had frozen, so I was remaining silent for a moment. Can I address the scheduling issue for just a few seconds?
You may.
Thank you, Your Honor. As you can see from Apple's schedule and Epic's schedule, both parties recognize that completion of document or data production in early January is I think we hope a reasonable goal. Get that done right by the time the holidays close out, and then turn to depositions and expert work. The toggles, if you will, in the schedule, I think Epic proposes that all depositions take place between January 4th and February 5th, whereas we would extend that by about 3 more weeks. Epic has told us that they intend to take at least the 10 depositions permitted under the rules. Obviously, as well, Your Honor, there will be third-party discovery, and that will involve, scheduling with third parties as well as getting their compliance with discovery obligations. Having documents produced by early January, followed by what we have is about 7 weeks of deposition discovery, to us seems like the practical and realistic approach, and one that can actually be achieved, and that we will not be back to the court asking for further relief on the schedule. So that was the thinking in the schedule that Apple's put forward. And then the other, I think, flex points in the schedule, if you will, are the timing of the expert reports vis-a-vis dispositive motions. Apple's schedule has dispositive motions after the expert report process is completed, if you will. And Epic's, they call it their compromise schedule. Epic's schedule has dispositive motions after the opening expert reports have been filed, but before the rebuttal experts.
Your Honor, may I just respond to a couple of things there? All right, thank you. I would just point out that in our 6-month schedule, which is a schedule that anticipates that there would be a trial, probably, I don't know what Your Honor's practices will be or the courts will be in terms of impaneling a jury, but that it allows a trial in the absence of a jury. It also, because it would be a bench trial, does not have dispositive motions, and so that is not built into the schedule. If we build dispositive motions into the schedule, what we did on the 8-month schedule is allow the initial expert reports to come in on February 19th prior to the initial dispositive motion being filed. And we followed then exactly the same timeframes that Apple had in its papers for dispositive motions. So the difference is whether or not we're going to have more than just the opening of the expert reports for the dispositive motions. Again, we don't think that we, right now, we would like to have it tried by the bench in particular also because not only is it an equitable claim, but because of COVID and the uncertainty of when we're going to get a jury and the concern that that might be some time. But that will take.
Judge Freeman is picking a jury in a Cisco case for next month. We are trying hard to pick juries here. You are right. We don't know what's going to happen. But we are trying. Okay. At least there are some things that you all agree on, so I'll order them. Last day to meet and confer regarding initial disclosures, October 5th. Complete your initial disclosures or state your objections by October 12th. Complete document production and data, you couldn't agree, so I'll give you January 6th. 2021. Do not intend to bifurcate. So I do need to know from Apple. I'll give you until close of business tomorrow, Mr. Doran, to let me know whether or not you're demanding a jury, or either one of you, frankly, given the counterclaims. Ms. Forrest? In general, and maybe I'll put it in the order, any deadlines I give, I'll always, they're always Pacific time. Okay, so to the extent it's not obvious, I'll make it obvious, Pacific time. Close of business. I know for lawyers it's midnight, for the courts, we'll say it's 5 o'clock, even though we all know it's not, at least not for the judges and the law clerks. All right, that's what I mean by close of business.
Thank you.
Once I receive those submissions, I will give you your schedule. Anything else you want me to consider?
No, Your Honor.
No, Your Honor, thank you.
You should know that I have a major class action that is being tried in June. So June is probably out. I think you're looking at a July trial date. As soon as I finish that case, I'll do this one. But that case is old. It's gone up to the Court of Appeal and back down, and I'm not bumping it for this case. Okay. Anything else you want to discuss?
No, Your Honor.
Thank you, Your Honor.
Case management conference, or once you get your schedule, you're good to go.
Your Honor, if you're asking if it'd be helpful to have a case management conference set, perhaps it would. And then after we see the schedule, if the parties agree it's not necessary, we can let the court know.
All right, that's fine. Does that work for you, Ms. Forrest?
It works for me. I mean, we're fine getting it just with the court order, but we're also fine to convene a conference.
All right, why don't we say, and you can let me know that there's no need. Should be fine. I'll put you on October 19th at 1:30 for case management conference.
And Your Honor, just to be absolutely clear, so there's no debate about it, we assume that as of now, we should be absolutely sort of full steam ahead to get everything done for document production, that we not waiting for the case management conference for that purpose.
I think if you don't want to fall behind, you better start now.
Thank you.
So, okay. Any other questions?
No, Your Honor.
All right, then. Everybody stay safe. I'll take it under submission. You'll hear from me in writing. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.